People versus Brian James, case number 226265.
Good Lord, Your Honor, my call on behalf of the people.
Thank you, Your Honor. Richard Tushkering on behalf of Mr. James.
Is Mr. James present?
He is not here.
Okay. Have you had any contact with him recently?
I have not, Your Honor. The last contact that I had with him was in mid-December. He had contacted my office, updated his phone number. I have not been able to reach him. Admittedly, I've been trying since probably about mid-January.
Okay. So you've been making some efforts for a while?
Yes. I've tried to reach him via email, text message, and if the phone number gave us.
Okay. Mr. Rolla, take any position on this?
Well, Judge, perhaps there's some irony in the fact that the defendant has not appeared, and in fact he's also facing fleeing charges. But in any case, I think eventually it would be appropriate. This matter is scheduled currently, as courts are all aware, for a jury trial. It's a secondary trial to the Matthew trial, which is scheduled the 24th through the 29th. This was scheduled the 24th through the 25th. But in either case, we have numerous witnesses outstanding, subpoenas, including one that may be coming from North Carolina if necessary. So we'd like to know the court's position.
All right. So Mr. James previously had a failure to appear. He absconded from July of 2023, it looks like, until October of 2024. So over a year the last time. So the court will order that his bond be revoked, that a bench warrant be issued for his arrest. The court will adjourn the jury trial currently set to begin on February 24th until Mr. James is apprehended and brought before the court. And we'll go from there. Mr. Roll, anything further on the record?
No, Your Honor.
All right. The only other thing I would state for the record is once Mr. James is apprehended, he was, the last time in October when he was picked up, he was given a $50,000 cash assured bond. Apparently he was able to post that. The court will order that he be held without bond once he is arrested.
No, Your Honor.
Thank you. That's all for this file. People versus Eric Ball, case number, well, we have a number of different files up for hearing today. 246733, 6746, 6771, 6772, and 6788.
Thank you, Your Honor. Richard Tushkering on behalf of Mr. Ball. Your Honor, this is the date and time set for status conference. We've been here a few times on status conferences, but we were waiting for all the files to work their way up here. We now have all of them up here. We would like to have them docketed for trials. I'd say we are still negotiating with the prosecutor, so I do think a final status conference does have some value, but at least at this point, it appears that all of these are going to be going to trial. I would also indicate I think Mr. Ball has a sentencing in March 6th on a child support matter. So again, just so the court has a clear view of everything's going on.
Okay. Mr. Rolla, in terms of scheduling for trial, are there certain files that you're going to seek to consolidate?
Thank you, Judge. In fact, I was just going to bring that to the court's attention. All of these matters arise out of the very same type circumstance. It's alleged in basically every file, depending on how you want to deal with it. The defendant claimed he was going to be doing body work, engine work, mechanical work for various high-priced motor vehicles, restoring them. But although he took the money, he didn't do anything, and he did it repeatedly to the extent that this is no accident. We would be actually filing a motion to consolidate all of his trials, or at a minimum, have it the evidence in the other trials be admissible either under 404B or 609.
Are you going to be imposing consolidation?
I'd like to talk to my client about it a little more, but frankly, I doubt we're going to oppose consolidation.
Okay. All right. So before I set for trial, I do want to know which, if any or all files are going to be consolidated. So I don't want to start scheduling until we know that. Mr. Roll, I'm gonna give you 30 days to file a motion to get that set for hearing on March motion day. Whether it's the early March motion day or the mid-March motion day. There's no objection, then we'll schedule them at that time. If there is, then we'll have the hearing, the court will decide and we'll schedule. So, do you have any objection to that, Mr. Church?
No, Your Honor, and I will discuss that issue with Mr. Ball and let the prosecutor know probably within a week to 10 days what our position is going to be on that. I would be surprised if we're going to oppose it because I think that the defense frankly benefits from that in the same way that the prosecutor does, and then it gives a full picture.
All right, Mr. Roll, any objections to that?
No, Your Honor, I think that's appropriate.
All right, so the status conference order will reflect prosecutor file motion to consolidate and set for hearing no later than the mid-March. Okay. Mr. Ball, do you have any questions?
No, sir.
Thank you, that's all. We have Mr. George present. People versus Damian George, case number 256789. Record should reflect Mr. George is present here in the courtroom.
Record, Your Honor, my phone has the people.
Thank you, Your Honor. Richard Church, appearing on behalf of Mr. George.
Church, can you tell me the status of this file this morning?
Yes, Your Honor. We're here for a status conference this morning. I've had some discussions with Ms. Broka in regards to this case, as I think she's ultimately the one handling it. Unfortunately, 2 weeks ago, I was ill most of the week, and last week, Ms. Broka was ill most of the week. So while there have been some discussions, I've sent a proposed resolution to her that I ultimately think she's likely going to agree to. We're just not there yet. So I'd ask the court to set another status conference for us in about a month's time.
Mr. Mola?
Your Honor, I do see in the file that there have been communications between my office and Mr. Truce's office. We have no objection to court rescheduling this for a second status conference. It may resolve itself. I would indicate, however, that there's a weapon involved. So any plea, of course, is going to involve the forfeiture of weapon under MCL 75239.
Okay, certainly there's been enough illness going around town for it to be understandable that that's caused a bit of a delay here. So the court will set this for a plea hearing status conference in 30 days. Do you have any questions, Mr. George?
Oh, Your Honor.
Okay. Thank you. That's all for today. People versus Lundy, case number 236668.
Thank you, Your Honor. Richard Church on behalf of Mr. Lundy for purposes of arraignment.
And this is set here today for arraignment on some alleged probation violations. Mr. Truce, did you have an opportunity to go through those with Mr. Lundy?
I did, Your Honor, and I had an opportunity to discuss with him the difference between the technical alleged violations and the non-technical violations. We'd waive a formal reading of the allegations. He would stand mute to the charges. I did screen him and approve him for counsel, but obviously I don't know who that's going to be yet. I suspect it would be me. And I'd ask the court to set it for a hearing. The next available date, I anticipate having some discussions with the probation department about potential resolutions. Also, obviously, one of the allegations is a violation of state law. We need to make determinations if charges may be coming or not.
Okay. The court will enter a not guilty plea on behalf of Mr. Lundy with regard to both the technical and non-technical probation violations. The court will set it for a hearing. Mr. DeLeo, any recommendations regarding bond pending that hearing?
We'd be okay with a PR bond, Your Honor. My understanding is Mr. Lundy's back at his grandparents, were supposed to be residing, scheduled to see his agent in Andrew County tomorrow. So as long as he continues to apply for that.
Okay, so the court will set this as a $1,000 personal recognizance bond. So Mr. Lundy, you don't have to post that bond today, but you do have to comply with all the conditions of your probation. And you have to appear for any future hearings. If you fail to do that, then you're responsible for that. Okay.
Yes, sir.
In terms of the hearing, Mr. Trush, are you requesting that within 14 days? Obviously, Mr. Lundy's going to not be lodged, so.
No, I would not ask the court to set it within 14 days. We'd waive that time requirement and just ask for the next available date.
Okay, so the court will set this out 30 days. We'll see where we're at that point. Mr. DeLeo or Mr. Roll, anything further we need to address on this file?
Not from the people making judgment. Nothing, Your Honor. Thank you.
Mr. Trush.
Nothing further.
Mr. Lundy, just make sure that you stay in touch with your attorney before that next hearing, okay?
Yes, sir.
And of course, make sure that you report as ordered to your probation agent. So, thank you. You have anybody else ready? I know we're ahead of schedule, Mr. Trush.
We have Mr. Woodworth. He's lodged in the county jail.
Yeah, for kidding them.
Yeah, never mind. Okay, thanks.
All right, sir, are you Michael Douglas Woodworth?
Yes,
Okay, are you able to hear me all right?
yes, Your Honor.
Okay, we'll go on the record in People versus Michael Woodworth. This is file number 256797, 6798, and 6799. The record should reflect Mr. Woodworth is present today by video from the Otsego County Jail. If I could have counsel put your appearances on.
Yes, Your Honor. Thank you. For the record, my parole have people.
Thank you, Your Honor. Richard Trish appearing on behalf of Mr. Woodworth. Hey, Your Honor, this is a date and time set for a status conference. This is our first status conference up in the circuit court. I have gone over the scoring with Mr. Woodworth, or I should say my scoring in the class with Mr. Woodworth. I've been in discussions with the prosecutor about potential resolutions. I would say we're not quite there yet, but I think we're closer than we are further apart at this point.
Okay, are you asking the court to set this for a separate date?
I would.
Please.
I'd ask the court to set it a month down the road. I feel pretty confident the prosecutor and I will either have an agreement by then or we'll be asking for a trial.
Okay, Mr. Rowland.
No objection, Judge.
All right, Mr. Woodworth, were you able to hear that?
Yes, Your Honor.
Do you have any objection to that?
No, Your Honor.
Okay. All right, thank you. The court will set this for a hearing, for a plea hearing in 30 days. If we have an agreement at that time, we'll enter the plea. If not, then the court will schedule this for trial. If counsel, if we're not going to have a plea, if the two of you can discuss and just determine whether there'll be any type of agreement on consolidation or not, so we can address that at the next hearing if there's no plea. That's all for today. Thank you, Mr. Woodworth. The court's going to disconnect at this time.
All right, thank you, Your Honor.
You know, Shane's here yet?
I have not seen him come up, but I will shoot a message.
You can,
Is the,
yeah, the AG is logged in, so if you can let us know once Mr. DuShane's present, we can get started on that case. We'll take a short recess until that. All right, Mr. Burke, are you able to hear me okay?
Good morning, Honor. Yes, I can. Can you hear me okay?
I can, thank you. All right, we're on the record now in People versus Sean DuShane, case number 246723. The record should reflect Mr. DuShane is present here in the courtroom today. If I could have counsel put your appearances on.
Your Honor, good morning again. For the record, my name is Mark Burke. My P number is 54935. I'm with the Attorney General's Office appearing for the people.
Thank you, Your Honor. Richard Church appearing on behalf of Mr. DuShane.
Okay, I know the parties have been working towards a resolution on this for some time. Mr. Church, can you tell me where things are at?
Yes, Your Honor. The Attorney General originally made an offer to us that contemplated Mr. DuShane reducing the arrearages to a certain amount and then pleading under a delay of sentence. Unfortunately, we just have not been able to meet the criteria for that. At the last hearing, the Attorney General had extended an offer in the alternative that if Mr. DuShane pled to count one, they would dismiss the habitual enhancement. We would seek to take advantage of that today.
Okay. Mr. Burke, is that a correct statement of the plea offer?
I'm taking a look, Judge, just to see. I didn't see that last offer that Mr. Truce just mentioned. Let me just take a look and see if the notes reflect that. I have to be honest, Your Honor. I don't see that in there. Typically, what the Attorney General's office would offer in a case like this would be for the defendant to plead to count one with a hab third, and we dismiss the hab fourth. But I don't think I've ever seen the Attorney General's office dismiss the entire habitual enhancement.
Okay. Mr. Truce, is that something that you had in discussions off the record, or did we get that on the record last time?
I do believe it was on the record that, and again, I think it was Mr. Awuda Coker, who I think has since left the Attorney General's office. But I do believe that he did indicate it on the record.
So, Mr. Burke, if you don't mind, I'm just going to double check that last hearing just to see if that is on the record. That'll only take me a couple minutes here to review
Of course,
that. And we'll see if that changes things. So I'm just going to put you back on hold, Mr. Truce. I'm going to go off the record for about 5 minutes, and then we'll come back on.
Your Honor, thank you.
All rise.
Six and one, you say that. And that was just to bring it up, but they didn't do all the other areas that was happening by the guy. It was supposed to do something. But that's big enough for insurance. It's insurance, 74% of it. So 25%. He was. Check. Way back once, took care of it, just on the 8 years. And that's crazy, we got more expensive on the other. We got 42,000 for one at school. Wow. Guess what? That's right. Yeah. Yeah. True. Right. It's constant. Yeah. I have been guaranteed. I mean, they still. I still been bad feelings. Okay, I didn't see. I did make sure she has. One of the important what she did. They were so afraid. They thought the school district was going to get sued. I wasn't vindictive. I wasn't sure what she did. What she did with somebody else. Right. Because then I would be my dad. Oh, that'd be worse. Last time she went to university. Apparently, I wasn't the first person she had shown less than favorite treatment. You know, if you were favorites. Let's just put it this way, those people with some very, very interesting benefits. Anyway. Three teachers, two of the regular school. And I really want. Yeah. Plus, some of them have some right. Then middle school on a Friday, 17. That's what it's going to happen. Well, I mean, it was okay, but it was the first time. Yeah. No, it's good. That's why we don't do it. I think it's 1.5. Well, I told him, can I not? interesting, so many slush funds like that, but they've already found almost $1 trillion. Oh, yeah. You can't take that away from us. Well, why? It's not. You have the right to get that. Yeah. You're using email, right? They assign you the email, they pay for it, they give you the phone, they give you the computer. Guess what? It's not your property, right? You have no reasonable expectation. Or just do it. That's what the judge ruled on Saturday night. So all of that down the treasury. Gee, here's some reading. We didn't want you looking at this one. What does that tell you? You knew you were doing things wrong, but you just reviewed it. So it'll be interesting. Oh. Oh, that's weird. That's not. Oh, I thought one was, because it's 6 through 12. Yeah, check. All right, I'm sorry. Yeah, if you have kids in school between 6th and 12th grade, you ski, snowboarding, on night rider at 2 o'clock. Wednesday, 2:30 to 8:30. All 30. I'm on the rise board. One of those snow conditions are going to be great. Maybe May.
Like July.
No, won't be that bad.
All rise, 46th Circuit back in session.
Thank you. Please be seated. Okay, we're back on the record. Mr. Trush, I actually reviewed the last 2 hearings just in case. And the last hearing was Ms. Williams from the AG's office. The previous one was Ms. McCree back in October. Neither of those hearings did the AG make any different offers. And the last hearing, you basically said that you were going to contact the AG with the authority to negotiate in between then and today's hearing if the original offer wasn't going to work. So
It's not the first time I've been wrong.
So maybe you did have those conversations since then, but nothing was on the record. So
And during the break, I did speak to Mr. DuShane. We would take advantage of the offer that's been proffered today.
okay, so Mr. Burke, that would be pleading to the charge with a habitual offender third. Is that correct?
That's correct, Your Honor. Thank you.
Mr. DuShane, did you have an adequate opportunity to speak to Mr. Trush about this?
Yes, sir.
Okay, is that how you want to proceed today?
Yes, Your Honor.
You raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Mr. DuShane, are you currently on any probation or parole?
Yes, Your Honor. 1 felony probation in Gaylord.
Okay. And who's your probation agent?
Justin Brunikel, I've talked to him about this and he said that because he believes this stemmed back before I got out of jail, that I shouldn't face any violations. And that was just on March 5th, or in fact, just this last week, that's what on the 5th Wednesday.
Okay.
So he knows about this.
All right. Okay. And you understand that the maximum penalty that you could face for the charge in this case, which as charged is 4 years, but with the habitual offender third would make that a maximum possible penalty of 8 years. Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all of those rights,
Yes, Your Honor.
and you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of that appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to enter that plea?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Okay, this covers the time frame between October 1st of 2021 and September 30th of 2022. At that time, were you subject to an order of the court here in Otsego County to pay child support?
Yes, sir.
Okay. And during that period of time, did you fail to pay that support in the amount required or at the times required by that order?
I believe so. Yes, sir.
And that was here in Otsego County, is that correct?
Yes, sir.
Mr. Trush, any additional questions?
No, Your Honor.
Mr. Burke, did you have any additional questions?
None with respect to count one, Judge. Thank you.
And then Mr. DuShane, had you previously been convicted of back in 2001 of breaking and entering building?
Yes, Your Honor.
And then also in 2001, okay, that's one of those was here in Otsego County, and did you also have a similar conviction in Emmett County?
I had a similar conviction in Charlevoix County and Crawford County, not Emmett County.
Okay, all right. Mr. Burke, are you satisfied with the basis for the enhancement?
I am, Judge. Yes, thank you.
Mr. Trush.
I'm satisfied.
Mr. Burke, are the people aware of any threats, promises, or inducements other than what's been placed on the record today?
None from the people, Judge. Thank you.
Mr. Trush.
I'm aware of none, Your Honor.
And Mr. Burke, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
We are, Judge. Yes, thank you.
Mr. Trush.
Defense is satisfied.
Mr. DuShane, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Mr. DeLeo, is Mr. Brunicello going to be the one to do the PSI, do you think?
He will, Your Honor. He'll reach out.
Okay, so when Mr. Brunicello reaches out to you, make sure you follow up with that, okay?
Yes, Your Honor.
The court will adjourn the jury trial currently set for February 28th in light of the plea today. Mr. Burke, anything further we need to address for your side?
I don't think so, Judge, except with respect to sentencing, is it okay if the people appear by Zoom?
Yeah, if you can just, whoever the counsel is going to be for sentencing, if you can just have them just submit something in writing prior to that hearing so that my assistant can note that for the record.
All right, very good. I'm making putting a note right here on my file, so I'll make sure the Lansing office knows that, Judge. Thank you so much.
All right, thank you, Mr. Trush.
Nothing further.
Thank you, that's all for today.
Thank you, Your Honor.
Your Honor, thank you very much.
Yep, you're free to disconnect, Mr. Burke.
Thank you, and thank you, Mr. Trush. Thank you. Have a good day, everyone.
Take care.
Mr. Bader, were you ready on Ms. Jones' case?
Your Honor, I am ready, but I do not see anyone by the name of Mr. Jones here today. You gotta forgive me, I have yet to actually meet Mr. Jones. I just subbed in temporarily yesterday. You also represent Dustin.
Mr. Kirby and so Kirby Newton. I did.
What do you want? Kirby? Okay, so we'll wait on Jones.
So Mr. Baber, we'll take Mr. Kirby and Mr. Newton's cases, and then we'll take a break so you can speak with Ms. Jones.
Come get you, don't.
Sir, can you tell me your name, please?
Dustin Kirby.
Okay, all right, we're on the record in People versus Kirby. This is file number 256790. The record should reflect Mr. Kirby's present by video from the Otsego County Jail. If I can have counsel put your appearances on.
Thank you. Regarding my call about people.
Jonathan Baber on behalf of Mr. Kirby.
All right, this is set for a scheduling conference today. Mr. Baber, can you tell me where things stand with this case?
Yes, Your Honor. My client will be pleading to a plea agreement with the prosecution. The plea would be to a domestic violence third offense and 1 count of resisting and obstructing.
So counts 3 and 4.
Yes, Judge.
Mr. Broka, is that a correct statement we offer?
I thought it was 2 and 4, but maybe it was Ms. Brooker's. But it was pleading to 2 counts for dismissal of the other 2.
Okay. It's gonna matter if it's 2 or 3, because
It
there's,
doesn't matter, Judge.
well, there's significantly different penalties.
Oh, I understand. That's what I want. That's why I want to see what Ms. Brooker's notes indicate. The last note I see, Your Honor, for the record was from Mr. Fornier in our office, and that's at the end of December. And it had counts 2 and 4, but I do see some references from Ms. Brooker subsequent to that, but I don't see it changing plea offer. She may have, that may be information I just don't have.
Okay, so are you willing to agree to counts 3 and 4 then today?
Yes, Judge.
Okay. All right, Mr. Kirby, have you had a chance to speak with Mr. Baber about this plea agreement?
Yes, sir. If there's a second, I could talk to him and maybe I forget what room it's called for a second before we start the case, if that would be fine. But I have had a chance to talk to him.
Mr. Kirby, I'm present in the courtroom and I don't have the ability to do a breakout room. Just so you're aware, everything we were just talking about, the plea is still pleading to a domestic violence third offense and a resisting and obstructing, one count. That's what we discussed. And if you need more time to talk with me before you accept that plea, are you asking this court for an adjournment today so you can have more time to discuss this plea with me?
No, it's fine. We can go ahead.
Okay. All right, thank you. Mr. Kirby, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, thank you. You can lower your hand. Mr. Kirby, are you currently on any kind of probation or parole?
No, Your Honor.
All right, and you understand that the maximum possible penalty for domestic violence as a third offense is up to 5 years and or a $5,000 fine? Do you understand that?
Yes, Your Honor.
And that the maximum possible penalty for resisting or obstructing is up to 2 years and or a $2,000 fine? Do you understand that?
Yes, Your Honor.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty today?
No, sir.
Has anyone promised you anything other than what we've said on the record?
No, sir.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are in fact guilty of this charge?
May
These
I
two
ask you
charges.
to ask that? Could you ask that question again? Sorry, I couldn't hear you.
Sure. Are you pleading guilty to each of these charges because you are actually guilty?
Yes, Your Honor.
The date that I have for this incident is December 2nd of 2024. Is that the correct date?
I believe so, Your Honor. Yes.
On that day, were you here in Otsego County?
Yes, Your Honor.
Okay. And did you have some type of incident with an individual, Maya Prahin?
Yes, Your Honor.
Was that somebody that you had a dating relationship with at that time?
Yes, Your Honor.
All right. And was there some type of altercation between you and her?
Yes, Your Honor.
All right. And did you make an assault and battery upon her at that time?
Yes, Your Honor.
Had you previously been convicted of a domestic violence charge back in 2018?
Yes, Your Honor.
And again in 2021?
Yes, Your Honor.
All right. And during that incident, did you come into contact with an officer from the Gaylord City Police Department?
Yes, Your Honor.
Did you know that that person was there performing his duties as a police officer?
Yes, Your Honor.
All right. And did you fail to comply with the lawful command or in some other way obstruct that officer in the performance of his duties?
No, Your Honor. I blew fluid from my nose in his direction.
Okay. And did you do that on purpose?
Yes, Your Honor.
Okay. All right, Mr. Roller, are the people satisfied with the factual basis?
People feel the court has sufficient factual basis for the court's acceptance of these two counts 3 and 4 as entered. I further indicate to the record, and I believe Mr. Bailey will confirm, there is restitution of $1,050 to the business that for the damage that occurred.
Okay.
And I acknowledge that, Your Honor. I went over that with my client. We do not object to the $1,050 restitution to the party.
And Mr. Faber, do you agree that there's a sufficient factual basis?
I do, Judge. Thank you.
Mr. Roller, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Faber?
No, Judge.
Mr. Roller, are the people satisfied that the court has complied with statute and court will take this?
Yes, Judge.
Mr. Faber?
Yes, Judge.
Mr. Kirby, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to each. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, you'll be contacted by someone from the probation department for a pre-sentence interview. And then you'll have an opportunity to go through that with your attorney prior to sentencing, okay?
Yes, Your Honor.
Mr. Roll, anything further for the record today?
No, thank you.
Mr. Baker?
Yes, Your Honor.
Mr. Kirby, you still want me to proceed with the argument for the bond reduction, is that correct?
Yes, Your Honor. I mean, yes, Baber. That's Baber speaking, correct?
That's correct.
All right. Yes, please and thank you.
Judge, if I may make a brief argument in regard to bond. Your Honor, I'm asking this court to consider a PR bond in regard to this case. My client has been unable to post bond for 3 months, and since being incarcerated, he's had several medical issues that have gone relatively unattended to over here at the local jail. My client has a plate fixated in the lower jaw. He has several rotten teeth that are broken that need to be removed. He was referred to the jail dentist by the nurse practitioner. The dentist would not perform any work on his teeth, would not pull any of the teeth until that metal plate was removed. The dentist referred my client to 3 different oral surgeons. Ultimately, the jail didn't follow up. The oral surgeons instructed my client it was on him to schedule that up and then seek a furlough to try to get that work done. While we disagree with that procedure, we did our best to try to make that happen. Unfortunately, none of them would accept my client's Medicaid. Further, several wanted payment up front. Eventually, this led to a second infection of my client's mouth, resulting in him being taken to the emergency room by jail staff, where he was found again with a broken tooth and abscess and given a higher dose of antibiotics. They did do an MRI on his chin and jaw because of how severe the swelling was. There was concern that the infection may have transferred into his bloodstream, and they did follow-up testing in regard to that. Ultimately, the emergency room said, this infection is just going to keep coming back until the teeth are removed. So I'm asking the court to issue a PR bond so my client can actually be transferred to Midland, and then hopefully he can resolve his issues there, trying to get out and take care of himself in his mouth. He's been in quite a bit of pain for 3 months. I'm sure this court's had a toothache before, like many of us, and it becomes quite troublesome when it goes untreated. So that's my request for the court to consider a PR bond under these circumstances.
Mr. Rowland?
Thank you, Your Honor. A couple additional facts, however. While we don't dispute the information Mr. Baber just put on the record, I think the court should also need to be aware of the following. The metal plate that the defendant had put in his mouth, as indicated in defendant's motion, was put in well over a year ago before he was arrested here in Otsego County. He was supposed to return, according to the information in defendant's motion, 6 to 8 weeks after he had that done, to have the plate removed. For reasons which are unclear and were not specified in defendant's motion, he chose not to go back to have that removed, and he caused the infection. And now the request is, of course, well, Otsego County should take care of this. The court's well aware that in circumstances where we're dealing with the type of assault that took place here, people express concerns that if the defendant's out on a PR bond, the victim may again be placed in danger of the defendant's own actions unless there can be some better control over how the defendant is out, where he's going to. I'd further point out too that all the defendant had to do was have an appointment arranged to where he was going to have this done, and the sheriff's department would have made arrangements either to transport him to and from that appointment, or his attorney could have brought simply a stipulation order to our office to have him get a day furlough or whatever it was for that appointment. He's chosen not to do so. He's created this mess, and now he wants the court to just let him go. There's some concern as to whether or not he's going to appear then for sentencing.
And the parties scored this out, Mr. Faber, set for sentencing, preliminary scoring.
Your Honor, just on a guessing calculation, as you know, I can't guarantee any scoring, but I believe it's going to be a straddle cell situation.
I don't dispute that, Judge. I think it probably will be a straddle cell.
Okay. All right. Given the status of this case, Mr. Kirby's entered a plea here today, so this is no longer an issue. Pre-trial release. Go ahead, Mr. Kirby. Did you want to say something?
I just wanted, yes, Your Honor, I just wanted to state for the record that I do have witnesses. I did show up to try to get the metal plate taken out to back to Detroit, and I went 3 different times with my mother and my ex-fiance, and both 3 times he rescheduled, and that's why I wasn't able to get the metal taken out, and nobody else wanted to touch the plates in my mouth, because usually the person that does the surgery is the person that they like to take it out. That's all I have to say.
All right, thank you. Mr. DeLeo, do you know who's going to be doing the PSI? This one?
I don't, Your Honor.
Is it possible, since Mr. Kirby's lodged, to get it done so we can get him on for sentencing at the beginning of March? I don't know what your guys' flow is like right now.
Might be possible, Your Honor.
Okay. All right, so again, this is no longer an issue of pretrial release. So Mr. Kirby's not entitled to bond at this time. I'm looking at this strictly from a health standpoint, and whether or not his condition justifies some type of PR bond or furlough. Given the nature of the charges in this case, given the likely sentence, which if it's a straddle cell, would include jail or prison time. The court is going to deny release at this point. Of course, if I always direct the jail if there's emergent issues that the jail can handle, the jail will contact me and usually request a furlough. And if that's the case, I certainly will consider it based on the circumstances. But as it stands right now, I'm not finding there's any justification for it. The court will request the probation department to try to prepare that report as quick as possible so that we can get Mr. Kirby in for sentencing, perhaps as early as 2 weeks, to try and get that taken care of so that he can move forward compared to any of his health conditions.
Thank you, Your Honor. And we're still on for March, I believe, 5th to hear and argue the second half of that motion.
Okay. As far as I know, that's still on record. Okay. All right, thank you. That's all for today. And to the jail, if we could have Mr. Knudsen, please.
Yep. Am I all done?
You're all done. Yes, thank you, Mr. Kirby.
All right, thank you, Your Honor.
All right, sir, can you tell me your name, please?
Yes, Your Honor, my name is Adam Knutson.
We're on the record now in People versus Adam Knutson, case number 256800 and 6801. The record should reflect Mr. Knutson's present today from the Otsego County Jail. If I can have counsel put your appearance on.
For the record, Your Honor, I call on behalf of people.
Jonathan Baber on behalf of Mr. Knutson.
Thank you. Mr. Baber, can you tell me the status of these two files here today?
Yes, Your Honor, I'm going to be seeking an adjournment in regard to this case already discussed. The prosecutor does not appear there's any objection to an adjournment. Ultimately, it's a situation where the offer and plea, as discussed with my client, may be different than the offer and plea that the prosecutor is willing to give today. So we're investigating that. We need to talk to the prosecutor to hammer out exactly what that would be, if there is going to be a plea in this case. So I'm seeking short-term adjournment.
Okay, Mr. Rowland.
No objection. In fact, Your Honor, according to the notes in the file, where you were still looking for some additional information, it won't affect the case specifically, but it could come into play for sentencing purposes.
Okay, Mr. Knutson, were you able to hear all of that?
I believe I heard Mr. Baber, but I did not hear the prosecution. Did they object or no?
No objection, and he basically agreed with Mr. Baber. Do you have any objection to what Mr. Baber is requesting here today?
No, he speaks on my behalf.
Okay, all right, so the court will set this for another hearing, and we'll go forward with that, go forward further at that time. Mr. Rowland, anything further that we need to address today?
No, Judge, thank you.
Mr. Baber.
No, Judge, thank you.
Mr. Knutson, do you have any questions at all?
No, Your Honor, I believe I am set.
Okay, thank you. That's all for today. The court's going to go ahead and disconnect from the jail at this time. And then Baber will take a short recess.
Thank you.
And then we'll come back on the record with Ms. Jones' case. See,
Yeah.
Were you ready on Ms. Jones' case?
Thank you, Your Honor, but it's not a good prosecutor's here.
Oh, I might be the other prosecutor that's handling that. We're on the record in People versus Paulette Jones, file number 246775. The record should reflect Ms. Jones is present here in the courtroom today. If I can have counsel from your appearances.
Thank you, Your Honor. For the record, I call on behalf of the people.
Thank you, Your Honor. Jonathan Baber on behalf of Ms. Jones, substituting in for Larry Brown.
Ms. Jones, do you have any objection to Mr. Faber representing you for the purposes of
No,
today's?
sir.
Have you had a chance to go through the pre-sentence report either with him or with Mr. Brown?
Yes.
Mr. Faber, are there any additions, deletions, or corrections to that report?
There are no additions, deletions, or corrections.
Are there any challenges to the scoring of the guidelines?
No challenges, Judge. Thank you.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Judge.
Anything on behalf of the people for allocation today?
Judge, as was indicated previously to defense counsel, this is a first felony situation. And although it is dealing with methamphetamine, I don't need to tell the court the dangers of that. This is also a circumstance where the people under the guidelines in this particular case, which are 0 to 3, would not have an objection if there was a request for 7411 as indicated in the PSI.
Thank you.
Mr. Faber, anything on behalf of Ms. Jones?
Just briefly, Your Honor, just going over some highlights that Mr. Brown would like me to address before this court before setting sentence. Ms. Jones is 49 years old with virtually no criminal history. There was a operating room visit that impaired in 2003, but it was so long ago that it was not scorable for purposes of today's sentencing. Ultimately, she's been with her husband for 20 years. The use and procurement of drugs is kind of relatively new to that relationship. Her husband is in prison now, and she's moving forward with her life in a positive manner. This was definitely outside of her character. If you look at her long history as being a law-abiding citizen who's diligently maintained employment. I believe that this has been such an ordeal and an embarrassment to her that that alone is going to be sufficient that she's not going to come before this court. I think she's going to prove herself very well on probation. I'm asking this court to consider adopting the recommendation for 7.11 probation for Ms. Jones.
All right, thank you. Ms. Jones, anything you wanted to say today?
I apologize, first of all, for being late and taking court time. And this is very embarrassing to me and my family. We took my husband in and he's spiraled out of control. Some medical issues into drug use and yeah, it's been quite an ordeal. And but myself as well, I should have stayed far away and kept on the right path, and I didn't, and I shamed my parents and myself, and I've never been in any kind of trouble. I've worked a job. I had the same job for 20 years, and this last one I'm on now 3. So I've not been without employment, and I maintain a good driving record. Everything.
I did read through the report, familiar with what happened in this circumstance. There's also information in that report about you and your background and surrounding circumstances. So I'm pretty well versed in all the relevant facts here that could go towards sentencing. I do think the recommendation is appropriate. I think some probation and some oversight to make sure that you get on the right track, stay on the right track for a period of time. It's beneficial to the community so that you're not back here, but I think it would be beneficial to you as well. And I think there's no reason not to give you an opportunity through 7411 to have this non-public. So I think it's, given all the circumstances, I think it's an appropriate resolution for this. The court is going to hold some jail time in advance so that there's extra motivation there to the extent that you need it, which I'm not sure that you do, but extra motivation to comply with probation. If you do comply and successfully complete your probation, you never have to serve that jail time. If you don't, though, that'll be a signal to me and to the community that there's something else going on here that requires more attention. So the court is going to sentence you to probation for a period of 12 months. The court's going to adopt as the conditions of that probation all the terms and conditions listed in the report, including that probation is pursuant to 7411. The court is going to impose 90 days in the Otsego County Jail with credit for 2 days served. Again, the court's going to hold that time in abeyance to be used at the discretion of the court. The court will impose fines and costs as follows: a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state cost, DNA testing fee of $60, and supervision fee while you're on probation of $30 per month. Because this is pursuant to 7411, there are no written appellate rights at this time. Mr. DeLeo, is Ms. Jones need checking with you before leaving here today?
Yeah, I'll speak with her for a minute.
Okay, so if you can just check in with Mr. DeLeo, he's going to give you some further instructions regarding your probation. Other than that, good luck to you. I hope that I'm signing a successful discharge. Thank you. That's all for today. People versus Broka, case number 256796.
Jonathan Baker on behalf of Mr. Broka was approaching the podium, Judge.
Mr. Faber, can you tell me the status of the file here today?
Yes, Your Honor. There's been a plea agreement offered to the client who wants to avail himself of. Client pleads as charged to count 1, the possession of a narcotic. They would dismiss the second offense notice.
Correct, dismissing drug double enhancement.
Correct.
Okay. Mr. Broka, have you had a chance, excuse me, to speak with Mr. Faber about this plea agreement?
Yes, sir.
And what we've just said here on the record as to the terms, is that your understanding as well?
Yes, sir.
Is that how you want to proceed?
Yes, Your Honor.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Broka, are you currently on any kind of probation or parole?
No, sir.
You understand that the maximum possible penalty you could face for this charge, which is possession of cocaine, is up to 4 years and or a $25,000 fine.
Yes, sir.
With that in mind, what is your plea to that charge today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, to appeal it or get it reversed, you have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here in court?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty of this charge?
Yes, Your Honor.
This happened on July 3rd of 2024, is that the correct date?
Yeah, I'm pretty sure. Yes, Your Honor.
On that day, were you here in Otsego County?
Yes, Your Honor.
And while you were here in Otsego County on that day, did you have possession of some cocaine?
Yes, Your Honor.
Did you know that that's what that was?
Yes, Your Honor.
Do you have any legal right to have any amount of it at that time?
No, Your Honor.
Mr. Brola, are the people satisfied with the factual basis?
Yes, sir.
Mr. Faber?
Satisfied, Judge.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record? We are not. Mr. Faber?
No objection.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in taking of this plea?
Yes, Judge.
Mr. Faber?
Second objection.
Mr. Broka, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, or you're going to meet with Mr. DeLeo here today before you leave the courtroom to set up a pre-sentence interview. Make sure you follow up with that and make sure that you stay in contact with Mr. Faber so that you're prepared to go forward on the day of sentencing. Okay?
Yes, Your Honor.
Mr. Roll, anything further on this case?
Not in this one, thank you.
Mr. Faber?
Thank you, Judge.
People versus Palaski, case number 246716. Yeah, counsel, so you're here to sign this case.
For the record, John, good morning, Judge John Steffi of Harris Law, on behalf of Ms. Palaski, we're present before Your Honor.
Okay, so this is the date and time for a final status conference. We do have a jury trial set for March 24th. So this would be the plea cutoff. Mr. Steffi, have you had a chance to speak with Ms. Palaski about her decision as any plea offers?
Judge, thank you. Yes, I have had extensive discussions with both Mr. Rolla as well as my clients. We do have a plea agreement we'd like to enter today. That would be a plea to an amended count 3, or added count 3, I suppose, which is reckless driving causing serious impairment of bodily function. And we're seeking to enter a no contest plea due to potential civil liability.
Can you tell me the maximum penalty for that charge?
Judge, yes, the maximum on that is a 5-year.
And Judge, that would be contrary to MCL 257.626, parent 3.
That's correct.
That's a C that. Correct.
That's reckless driving causing
Serious impairment of bodily function.
And Judge, the factual basis for it would be the same as the current charge.
We have a police report or something tonight.
Judge, I have the affidavit of probable cause of them.
We hand that to the courthouse.
Thank you. Thank you.
All right, Mr. Rolla, is that a correct statement of the plea offer in this case?
Yes, Judge.
And do the people have any objection to the no contest?
As long as the court's satisfied that that meets the requirements, I believe the request in this case is on the basis of potential civil liability, or I should say future civil liability.
Oh, so you don't have an objection to no contest?
For the record, no, Judge.
All right, Ms. Palaski, have you had a chance to speak with Mr. Steffi about this plea agreement?
Sure.
Okay. And what we've discussed here on the record today, is that consistent with what you've spoken to him about?
Yes.
Is that how you want to proceed today?
Yes.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can lower your hand. Ms. Palaski, are you currently on any kind of probation or parole?
I was on probation.
Judge, that's not true. She went to get pretrial monitoring interview. She's not on probation or parole in any jurisdiction. Thank you.
It's okay. That's all right. That's why you have your lawyer there to help you. Ms. Palaski, you understand that the maximum possible penalty that you could face for this charge, this added count 3, which is reckless driving causing serious impairment, that is up to 5 years as a maximum possible penalty. Do you understand that?
Sure.
With that in mind, what is your plea to that charge today?
No contest.
Right. Right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand that you have all of those rights.
Yes, Your Honor.
And you understand that by pleading no contest, you're going to be giving up and waiving all of those rights, including the right to have a trial. You won't have those anymore. You understand that?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead no contest?
No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Okay, I've reviewed the affidavit of probable cause. Mr. Rowland, have you reviewed that as well?
I have, Judge, when we ask, I believe we do a stipulation that that be marked as people's one and admitted for the purposes of court accepted the defendant's confession.
Do you agree that the information contained within that would support finding of guilt on this charge?
I do, Judge, as a lesser included offense.
Mr. Stefan, have you had a chance to review it as well?
I have, Judge.
Would you agree that it would provide a factual basis?
Yes, I believe it does, and I don't have an objection to it being marked and admitted.
The court will admit this as People's Exhibit 1 for purposes of factual basis. I reviewed it and I agree that it would provide a factual basis. The court also finds that potential civil liability is an adequate basis for no contest plea. Mr. Rolla, are the people aware of any threats, promises, or inducements other than ones been placed on the record?
No, Judge.
Mr. Stefan?
I'm not.
Mr. Rolla, are the people satisfied that the court has complied with statute or only taking in this no contest plea?
Yes, Your Honor.
Mr. Stefan?
I believe you have complied.
Ms. Palaski, the court finds that your plea is knowing and voluntary. The court is satisfied based on the information contained within People's Exhibit 1 that there is an adequate factual basis to support a finding that you are guilty of this added count 3. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to meet with Mr. DeLeo from the probation department to set up a pre-sentence interview. It's important that you follow up with that and that you stay in touch with Mr. Steffi so that you're prepared to go forward on the day of sentencing. Mr. Broka, anything further that we need to address for the record today?
No, Judge. This time, thank you.
One thing I did, because this is set for trial, it might be plea today, the court will adjourn the trial dates are set for March.
Very good, thank you.
Thank you, Judge.
Mr. Steffi, anything further?
There's nothing further, Your Honor. Thank you.
Thank you, that's all for today.
Thank you, Your Honor.
TV oven?
What's that?
Move the TV oven?
No. Mr. Blumberg, are you able to hear me okay?
I sure am, Judge. Thank.
Okay, and you have Miss Martin with you?
She is here.
All right, Mr. Fornier, can you unmute, please?
Yep.
Are you able to hear me, Mr. Fornier? Can you hear me okay?
Yes, I can.
We're on the record now. This is Martin versus Fornier, file number 23-19345. The record should reflect that all parties are present by Zoom video. This is set, I believe, as a status conference today. Mr. Blumberg, can you tell me where things stand with this file?
Sure, Judge. We had a referee hearing some time ago on the issues of changing custody and a motion to revoke the Revocation of Paternity Act. It is clear and unequivocal that Mr. Fornier is not the biological father of one of the minor children. The referee made a ruling of which we filed a timely objection. We appeared before you on February 3rd, at which time Mr. Fornier failed to appear. You then rescheduled this matter for today.
Okay, that's right. All right, thank you. I do recall this now. I appreciate that update. Mr. Fornier, can you tell me why you weren't present at that previous hearing?
I did not receive any information about the previous hearing until the 7th, and when I got the notice for this hearing.
Okay. Are you asking the court to enforce that order of the referee?
Wait, to keep the parenting time how it is?
Right, so the referee issued his order, Ms. Martin, through her counsel, they've objected to that. They're asking the court to make a different decision than what the referee did. So I just need to know how you want to go forward. If you want the referee's order to take effect, then we'll proceed with the hearing. If you don't, then there may be some other type of resolution.
I would like to keep it how the referee has it, yes.
Okay. All right, so the court will set this for an evidentiary hearing, Mr. Blumberg, on your objection. How much time do you believe that we would need for that hearing?
We'll probably need a full day, Judge.
Okay. Do you need any particular period of time to get your witnesses subpoenaed or ready to go, or just set it as soon as possible?
Judge, I feel at least compelled to at least make a record on Mr. Fornier has never filed a response to any of the pleadings filed in this case. He failed to appear at the last proceeding. The proof of service is in the file. He just chose not to appear. And I would hope the court would at least make some finding as to his non-appearance. If the court doesn't award costs, that's certainly within your discretion. But he has just shown a lack of interest in this file by not even filing responses to any of the pleadings that have been filed. It's really kind of put us at somewhat of a disadvantage. And I respectfully would ask the court to at least address the issue.
All right, well, I mean, I don't know that Mr. Fornier showed a lack of interest. He failed to appear for the last hearing. He's provided me with a reason for that. I think if the situation was reversed and you or your client failed to appear, and gave me a reasonable explanation, I don't think I would hold it against you. And I don't think his failure to file a written response to your objection, I'm not sure that he's required to do that.
He didn't even file a response to the original motion.
Okay, well, I mean, you can argue the legal effect of that if you want. This is a status conference, scheduling conference today, so I'm not going to make any decisions on that. I mean, there's times when even attorneys don't file written responses to objections to referees' orders. So I'm not sure I can hold that against him.
No, you've reminded me of that as well. It's probably best I not say anything. I think the court had a much different view of this on February 3rd when we were last before you.
All All right, well, I mean, again, you're free to make any and all legal arguments based on what Mr. Fornier has or hasn't done during the pendency of the motion. And I will certainly take all of those into account. In terms of the scheduling though, do you need any particular time to be ready or just the court's soonest available date?
Well, I would think within 30 days. I mean, again, I would hope that Mr. Fornier would file a witness list, an exhibit list, or at least something so that we knew in advance. So when you ask me how much time we're going to need, I guess I should probably be somewhat cautious because I don't know what he's going to do, who he's going to call, or what exhibits he's going to use.
Okay, Mr. Fornier, do you intend to call any witnesses at that hearing?
Yes, I do.
Okay, how many witnesses are you going to call?
Probably 2 or 3.
All right, so the court will set this for a one-day evidentiary hearing. I'll set it at least 30 days out. I will require both sides to exchange witness and exhibit lists within the next 14 days. So Mr. Fornier, Mr. Blumberg already knows what that means. Mr. Fornier, what that means is you need to put in a written list, either in typewritten or legibly if you're going to handwrite it, with any witnesses that you intend to call and exhibits that you intend to introduce. You need to list those out and provide those to Mr. Blumberg, and you need to send that at least 14 days from today's hearing, okay? Or within 14 days.
Okay, thank you.
Do you have any questions about that?
No, I do not.
Okay. Mr. Blumberg, anything further that I can address for your side today?
I don't believe so. Thank you.
Okay. Mr. Fornier, do you have any questions at all?
No, I do not.
Okay. All right, thank you. The court will send out notice of the date and time of that evidentiary hearing to all parties and we'll proceed at that time. Mr. Blumberg, if you want to remain connected, I think I have counsel for the other 1045 in the waiting room.
Okay, thank you. I just haven't seen it.
Okay, Ms. Lesnick, are you able to hear me okay?
I am.
Okay, we'll go on the record in Casper versus Casper. This is file number 2419733. If I could have both counsel put your appearances on, please.
Yes, thank you, Your Honor. Jennifer Zalesnik appearing with and on behalf of the plaintiff Rebecca Casper. I just wanted to make sure that Ms. Casper is present via Zoom today, Your Honor.
I do not see her in the Zoom waiting room.
Okay, let me, if you don't mind, Your Honor, I'm gonna message her so that she can join. She might be having some trouble here.
Okay.
Okay, I messaged her, Judge, so hopefully she'll be logging in shortly.
Okay, can we proceed with your motion?
Yes, Your Honor, I'd be happy to do so.
Okay, so we're on the record today for two things. Number one, a status conference, but number two, plaintiff's motion to compel. I did have a chance to review your motion, Ms. Zalesnik. Is there anything that you wanted to state by way of oral argument?
Yes, Your Honor, I do want to note that Mr. Bloomberg did send me a response. The signature on the response shows February 13th of 2025. In reviewing the response, I noted many missing pieces or missing requested information. I sent an email to Mr. Blumberg on February 15th of 2025 regarding missing information. And I can show the court, I can share the screen with the court. To date, unfortunately, I have not received a response from Mr. Blumberg or the documents that were missing from the response. We're currently scheduled now for mediation on March 19th. Ms. Casper has scheduled an appraisal of the marital home for February 20th. With the missing information, I'm simply unable to, I guess, fully determine the marital estate. And it's been going, and I've been trying to get this information from Mr. Blumberg for months, since December 31st, when I came on and emailed him. And now he's just sending a response that's just not fully complete. So I'm, number one, asking the court order Mr. Blumberg to produce the information immediately before the close of business today, because he says he's had plenty of time. And order sanctions. I don't know if attorney fees are appropriate or sanctions, but my client should not bear the costs of enforcing a discovery request that was appropriately sent. I've reviewed the financial disclosure that Mr. Casper provided. It was negligible. There's no way for us to do our job and make sure we are determining the marital estate without sufficient information. And Mr. Casper is the only one that can have that information.
All right, are there specific, can you tell me which specific ones that you feel were not answered adequately?
Yes, so number one interrogatory, no statement was provided regarding the retirement. That also would be missing number 2 and number 3 of the request to produce. Number 3 of the interrogatories, no documents were provided regarding the debt. So there
let me just stop you for 1 second. So I want to go back to your first statement. You're saying interrogatory number 1?
Yes, let me pull it up.
That references life insurance policies, not.
It might be under the request to produce. Let me pull it up. I was trying to be concise with it before you pulled it in. So it's number 2. It's number 2. Sorry, Your Honor. So copy of the most recent for the contributions for the deferred compensation, and number 3 are not provided. He does note in his response that there's retirement, but he doesn't provide a current statement. Then you go to number 3 of the interrogatories that requests any debts you allege are marital. So there's nothing indicating that he's not considering the debts that he's provided information for, but he does not provide statements. I don't even have statements for the mortgage on the marital home, which I've been asking Mr. Blumberg for. It's my understanding that the defendant's grandmother loaned the money for the purchase of that property. And then there's some sort of amortization schedule. She's not really 100% clear, but under the order that was entered on 10/7, Mr. Blumberg is supposed to be providing statements regarding the debts that she's paying. I haven't received anything, and neither has my client. Then we go to, so number 3 of the interrogatories, which would then correlate with number 11, is not answered. Number 5 of the request to produce is not answered. And I also sent an email to Mr. Blumberg. I said, I will need current bank statements. You have provided me with December statement for the checking account and September for the savings account. Those were both December 2024, September 2024. No current statement. I will need current statements for the Robinhood accounts. I will need verification of the outstanding mortgage balance on the real property, including lots 116, 117, and 118. I will need actual retirement statements for the most recent closing date. And then I will need the most recent loan statements for any vehicle, ORV, and motorcycle debts. And I sent that on 2/15, which was a Saturday at 11:11. But I received absolutely no response from Mr. Blumberg as it relates to that email.
Okay, Mr. Blumberg?
Well, Judge, my client's present today, and he has provided me with 3 of the 5 statements that have been requested. We provided the statements that he had through December. Here we are in February. So if council requires January statement, we will provide that. The Robinhood accounts, he's got these in with him today. We will provide the mortgage balance as of February 1. And I don't know what she's talking about, the closing dates for the retirement. I have no idea what she's talking about in regard to that. Certainly balances that are on the vehicles. It was my understanding that those were also available to her client, but again, we will provide those to her. I mean, I don't know what else I can do, Judge. I don't have access to these. When my client gets them, he gives them to me. I send them to counsel. That's all I can do.
Okay. All right. Can you provide that information to Ms. Selesnik within the next 7 days?
Yes.
Okay. All right. So yeah, I reviewed the motion. The motion was based on a non-response. Now we've got responses, and it sounds like more responses. So, Ms. Selesnik, I guess what I'm going to do for purposes of today's hearing as to the motion to compel, number one, I'm just going to order that Mr. Blumberg turn over the information that he's just gotten here today to you within 7 days. Then I guess at that point, I'm going to ask that you review that new information and then identify, to the extent that there's anything that you feel is still outstanding at that point, identify those items in writing to the court and to Mr. Blumberg. And then if necessary, I think we'd have to have a continuation of the motion to compel. So to the extent that the answers you've gotten you feel still aren't sufficient, then Ms. Selesnik, I'm just going to ask that you renotice this motion so that I can address the specific requests and then Mr. Blumberg's responses, and then make a determination as to whether they're adequate under the court rules or not. Okay.
Okay, I am asking for attorney fees, Your Honor. My client, we had to file this motion because Mr. Blumberg was simply not responding to us. He would send a vague response of anything, and it was only on one time on January 6th. I attached the email communication. This should be something that's just a normal course of business for an attorney that works in family law, or at least communicate with me. That's just not the case here. So I'm asking for, my client should not have to bear the costs of having to compel discovery responses.
So the way I would handle that, because what I'm hearing from Mr. Blumberg is that he's instructed his client's not providing him the information. So the way I would address that, Ms. Selesnik, where it's not the attorney, but the client, is as part of the overall divorce proceeding, if there's not an agreement reached, then to the extent that Mr. Blumberg's client is dragging his feet or not giving his attorney the information that he knows he's supposed to give his attorney, then I would hold that against Mr. Casper as part of the court's consideration of dividing up assets or debts to marriage. I mean, to me, that's a fall under kind of the fault category of things. So it's certainly something I'm taking into consideration, but I don't know that it's at this point. I'm not at a point where I feel imposing attorney fees is justified.
So are you reserving the issue of attorney fees?
Yes. And then, is there any dispute that the parties do have mediation scheduled for March 19th? Mr. Blumberg, is that correct from your standpoint?
I don't know. I got an email from counsel saying there was some conflict either with her schedule or her client's schedule. That was my understanding as to the date. We're getting this appraisal done this week, apparently. So if she can confirm that both she and her client are available, then I guess we can confirm that.
I have confirmed that, Your Honor. We're waiting for Mr. Blumberg to respond to Ms. Rundy's email. And that would be
All right,
on
so-
March 19th at 11 a.m.
Okay, so I'm gonna set this for another status conference in April then. If the parties have been able to resolve things, then at mediation, we can use that time to enter judgment. If they haven't, then we can schedule hearings to get the matter resolved.
Judge, one of the things I think you should be informed of is that the parties apparently have resolved the issues of custody and parenting time. Counsel has
Okay.
failed to inform the court of that.
Oh, my goodness, no, there's
That's
no
fine.
objection that's been filed.
Right, so it's been resolved.
Yeah.
Okay, Ms. Lesnick, any objection to setting it for a status conference in April following the mediation?
No objection, Your Honor.
Mr. Blumberg?
No, that's fine, Judge.
Okay. All right, thank you. That's all I have for today, and both parties are free to disconnect at this time. Ms. Lesnick, just so you're aware, your client did not sign in. She's not in the waiting room, so.
Okay, all right, thank you, Your Honor. Oh, I want to
Okay.
clarify, do I need to prepare the order or will the court be preparing the order?
The court will put out the order resulting from today's hearing.
Okay, thank you. Have a good day.
Thank you.